Welcome to Future Proof Your eDiscovery Practices, sponsored by Hewlett-Packard. They're also the sponsors of our LegalTech app, so if you haven't downloaded it yet, please do so. It's my great pleasure to introduce the moderator of our session today, George Sahanis. He's the Vice President of Strategy with HP Software. Please join me in welcoming George.
Great, well, thanks very much, and we're very fortunate today to have a great panel to talk about this subject. To my right, we have Jessica Watts. Jessica is AGC and Lead Discovery Counsel for Hewlett-Packard. To her right is not Patrick Collins, so if you are a former Illinois politician, I have good news for you today. He's not here, but Barak Cohen is. Barak Cohen is a partner at Perkins Coie. He also recently left the DOJ, where he was at the main component for the DOJ and the criminal division in Washington, D.C. And to Barak's right, we have Bruce Hartley. Bruce Hartley is VP of Consulting at Celerity Consulting. So with that, we're going to cover a few topics today that we think are highly relevant as it pertains to the future of eDiscovery and what the future of eDiscovery looks like. We're going to talk about really a few key topics. One is what we call the rise of the machines and what this implies for the fact that information is being generated by things that are not human. The criminal investigations component. And so for many of us that have worked in eDiscovery for a while, we've talked a lot about the civil aspect of litigation, the civil aspect of discovery, but more and more the government is taking a much more proactive, if that's a word you want to use, stance and view around getting information. And so the criminal investigation element, the DOJ and foreign criminal jurisdictional agents, it's relevant today. And then we go into information border wars, and this is the next thing that we're already seeing. And then finally, what does the model of eDiscovery look like in the future? Using a hypothetical that's somewhat based in the real world today, but it's showing you how all of these pieces are going to come together in the context of eDiscovery. So the first thing I wanted to talk about then is what we call the rise of the machines. And if you remember back in the day in your first class in property, you might remember this case, right, which is who owns the fox at the end of the hunt. And really, if you think about discovery from this point in time forward in American jurisprudence anyway, discovery has very much been the same from one perspective, which is it's always been based on what somebody said, what somebody represented, what somebody created, maybe what somebody shared. But even in eDiscovery, there tends to be a human involved somewhere along the line. They wrote the email, they received the contract, they reviewed that thing, they sent something else along. But what's happening today is that that's probably going to start to change and already has, where so much of the information that's actually being created and disseminated and shared may never even touch a human being. It may not be something that's originated by a person. It may not be something that actually is consumed by a human being. Or if it is, it's on a rare piece of that puzzle. This graph is showing you, or this chart is actually showing you, basically the CAGR and the expected growth rate of intelligent components going into different devices. And it's everything, right? And it's not just the intelligent phones, it's not just the iPads that we think about. It really is everything is going to and is having embedded forms of intelligence. Now, since 2003, the world economy has actually produced more transistors, right, the components of a CPU, at lower cost than grains of rice. As a matter of fact, as you know, it doubles about every 24 months. So it's a phenomenal growth rate since 2003, but these miniaturization of the technology allows all of these things to go into components that start to share things. And so you'll see the mobile apps, what happens in everything from baby monitors to health and fitness wearables. And it has a different implication as well, which is it's not just the amount of information that's being created. As you increase the amount of information, you actually have a two orders of magnitude increase in the patterns within the information. So you increase information 100 times, the number of patterns within the information actually is about a 10,000-fold. That's 2 orders of magnitude multiplication. So as we think about predictive analytics and we think about intelligent applications, being able to sift through this data, they have to be really much more intelligent over time to be able to go through these different patterns. And the types of information that I'm talking about, in the context of an enterprise today, and you'll see as we bring into the hypothetical, are things like a major telecommunication company today, on average, has over 500 million security events that are generated by its systems. Right? Those are things that rarely actually see have an individual take some sort of action. Some very small number will, but they actually become very relevant. Our own systems, we produce 1 billion DSN entries a week. And we're able to tell things like applications are trying to talk to a foreign jurisdiction that it shouldn't be, or you're able to identify the fact that there's some application trying to reach out to an entity that is prescribed. More and more of the information, though, is being generated with limited human involvement, and this is information that actually is turning out to be relevant. And so one of the big themes that's coming out of, that we believe is coming out of this, is that we're going to rely a little bit less in time on what people actually say, and instead what the machines that they're using tell us. And you'll see this in the hypothetical. So with that, I'm going to turn this over, and we're going to turn this over to Barak, and he's going to talk through the criminal investigations in the digital age, and this title that I've used here, which is the search first and ask questions later stance of the government.
Thank you, George.
Yeah, no, you can sit.
Good on you.
Whatever you
Okay,
want.
great. Okay, so for a good part of my my time at the Department of Justice, I was actually involved in investigations and prosecutions that depended heavily on electronic evidence. So I had a lot of experience dealing with ISPs and various corporate entities in the technology industry. And what I found incredibly interesting then, and what's incredibly challenging for me now, is that the government thinks it needs, and objectively, to some extent at least, does need a vast amount of the electronic data that George was alluding to in its investigations, but lacking a comprehensive current legal process often becomes over-aggressive in what it tries to get for its investigations and prosecutions. And what I'm trying to say is that, and I'll touch on this in one of my later slides, what I'm trying to say is that the current legal process doesn't really respond to the technology as it exists now. The technology has outstripped the legal process, and in that vacuum, the government does what it feels it needs to do, which is to move forward with law enforcement. And that's obviously a danger and a challenge for us, because in doing so, they're not necessarily looking or paying appropriate attention to privacy interests. And in doing so, they're not necessarily appropriately sensitive to proprietary interests. So what I hope to do in the few slides that I'll cover is not to comprehensively address these issues, but to point out some of the pressure points and some of the areas I saw as a prosecutor that resonate with me, especially now as defense counsel. So you can see here on this slide describing some of the government's ability to get information. It does indeed have broad rights through legal process to get information. Those rights are, of course, subject to the Fourth Amendment and to the Electronic Communication Privacy Act, ECPA. But again, there is that problem at bottom, which is that the Fourth Amendment and ECPA don't really respond to the state of the technology today. So indeed, while the government does require a facially valid legal process to search and seize electronic data, that facially valid process doesn't necessarily respond to all the constitutional principles that we really ought to be considering, and that I submit to you, you might want to consider in your positions when you decide whether or not to comply with government requests or whether to push back. And again, that's an issue I hope to touch in later slides. And then I also don't want to forget the last point here, which is that in addition to data, the government often wants witnesses. So when I was a prosecutor, I often wanted witnesses from ISPs, from technology companies, who could provide a very distinct purpose at trial, which is essentially to authenticate data, to explain the technology, to act as a record custodian. And both at the time and now, I recognize that can be a pretty heavy burden for companies. So there's a role to be played for you as in-house counsel, for those of you who are in-house counsel here, in negotiating how the government tries to get data custodians and witnesses and people that needs at trial without being overly burdensome. Okay, some issues as to government requests for data. First couple of bullets here. The government requests data both domestically and abroad. The government has investigations, for example, in the area of Foreign Corrupt Practices Act. And some of these foreign requests for data especially are coming to a head. I think we're all aware of Microsoft's current posture with respect to its case in the Second Circuit and the seizure of data from Ireland. So these requests from data can be expansive both in terms of the data itself and geographically speaking, obviously a challenge. From my perspective, particularly now, it's challenging because the government's requesting data from third-party vendors. So the privacy interests become all the more acute when you're talking not about the targets of an investigation, but companies dealing with all kinds of clients and customers. And when the government wants that data, the company, as a third party, really needs to consider whether or not there are other privacy interests at stake. I know you're all well aware of that. And of course, that last point, the request to third parties, the government's not always aware of who has the data, and you in industry are always aware of this, I know, or trying to be aware of it, but the prevailing question is, are you obligated to protect that data? Do you need to push back? And I think those two questions really are interrelated because, as I'll point out later, there is room to push back with the government in a way that doesn't necessarily create problems for the company or draw attention to itself. Okay, here's the essential problem. More data, more problems. Ties directly back to what George was discussing in his Rise of the Machines discussion. There's more data right now. As more data gets stored long term, the government wants access to it because the more data the government has, the easier it is for it to make its cases, the easier it is for it to bring expansive, challenging cases, and the more likely the government is to prevail at trial when it presents this evidence. Of course, the problem is that the more data you have, the more privacy interests are at stake, and the more difficult it becomes to easily tell the government, yeah, we can provide you X data based on this legal process, because now you have to consider all the expansive collateral consequences of data being sought that doesn't necessarily relate to a target, or perhaps provides too much information regarding a target and doesn't properly balance constitutional interests versus the government's need to investigate its cases. So you can see here, I've listed a few key cases, some of which I'm sure you're aware of, where courts have supported the government in its expansive searches for data. The Microsoft case, currently ongoing, still unresolved. I don't want to predict where that's going to go, but obviously very, very problematic for us in industry. The Skinner case here leads to the problem with cell signal tracking. The government position, of course, is that cell signal tracking isn't sufficiently precise to really present a privacy problem. But the technology is so relatively new, at least with respect to the case law, that I don't think the Fourth Amendment has really come to terms with what it really means to have all this data present and what that data can really mean as far as individuals go. Fortunately, the Supreme Court isn't entirely unaware of the challenge here. So you do see cases like Riley, which I've listed at the bottom, where the Supreme Court has firmly stated that the Fourth Amendment is still an important principle, even when the government is investigating in the electronic space. And I also point out the Warshak case here, which I think is a tremendous case for privacy advocates, where the court has invalidated, the Sixth Circuit that is, has invalidated portions of ECPA and said that despite what ECPA says, the government needs search warrants to get certain kinds of email data. So again, I want to loop back. I keep harping on this, but it's all about the obsolescence of the case law with respect to the Fourth Amendment rights. And so ECPA, it's obsolete, but it's still there. It's enacted in 1986, of course, hasn't aged very well. And the quote there you can see in the bullet comes from the actual legislative history of ECPA itself. I submit to you that ECPA as it exists today, or as it's applied today, does not strike a fair balance between privacy expectations of citizens and the legitimate need of law enforcement. And so there are a few distinct things that I think we all know ECPA fails to do. It really doesn't account for cloud-based email services. I mentioned the Skinner case and the problem with cellular devices and location data, which the government still has a very broad right to, as well as transactional data. The government has expansive capability to get transactional data relating to email. So some of the related questions here are, I think the most important among them are, whether or not you provide notice to account holders if you receive subpoenas or 2703D order. When I was a federal prosecutor, I would regularly, just as an analogy, I would regularly have agents serve grand jury subpoenas with requests that the recipients of the subpoena not disclose the existence of a grand jury investigation or alert the potential target of the investigation regarding the subpoena itself. And objectively, I don't think that's particularly off base. There is a need to protect ongoing pending investigations, but of course there's also a very real privacy interest at stake. So obviously a question here is, if you receive a third-party subpoena, is there a responsibility to notify the target of the investigation that the government is seeking information relating to him or her or to the corporate entity? So it's a real issue. Another related point, and again, this ties back to the Microsoft matter, what exactly is an ECPA search warrant? Is it kind of like a grand jury subpoena, or is it kind of like a physical search warrant for specific premises? So from the perspective of somebody deeply steeped in criminal law, both on the defense side and on the prosecution side, these are incredibly important questions. As a prosecutor, if you're trying to have a search warrant sworn out, you have to approach a magistrate judge in the very district where you're trying to get the search warrant. There's actually a physical premises involved, so the way the search warrant process, the way the actual search and seizure unfolds is completely logical when you're talking about a physical space, but when you're talking about an electronic space, the analogy starts to fall apart. You're talking about potentially the extraterritorial reach of a search warrant. So again, geographically, potentially incredibly expansive. You're talking about an electronic space versus a physical space. Physical spaces are decidedly limited in comparison with electronic spaces. So for example, if a prosecutor wants to seize a server, you're talking about vast amounts of data, and predominantly of which is benign and may not even relate to the search warrant or even to the investigation in question. Nevertheless, the government can theoretically at least seize that server and all its data, go through it, and then cherry pick the data that responds directly to the search warrant. So again, what I'm getting at here is that the current legal process just doesn't really fit the technology or the electronic space that it operates in. And to really draw a personal example of that, when I was a prosecutor, I was involved at one point in investigating a child pornography ring that was operating on a social networking website. And I offer this example in particular because I think for most people, child pornography rings, child sexual exploitation rings or conspiracies are things that we would tend, I think for most of us, we would tend to want to comply with legal process or cooperate with investigations. I don't want to speak for all of us, but I think most people are troubled by child pornography, at least to some extent. In any event, the challenging question from the government side in investigating this matter was, how does the government conduct real-time surveillance of this child pornography ring operating on a social networking website? Is that kind of like a Title III wiretap, since it's real-time surveillance? Should there instead be a search warrant because you're in a sense seizing or carving out part of the social networking website to conduct real-time surveillance? Or is it something that could be resolved as simply as a grand jury subpoena or some sort of ECPA order? And I don't want to go into the details of the solution that we came to when I was prosecuting this particular matter, but I'm pointing it out just to explain how the technology really has outstripped the legal process, and this should really give you food for thought when thinking about whether or not to push back against the government when the government comes to you with what appears to be facially valid legal process, and I think you kind of have to scratch your head and make sure that what the government's doing is appropriate. Okay, so responding to government requests, I'm sure a lot of you are already doing this, so I just want to very quickly emphasize some of the things that made sense both to me as a prosecutor and make sense to me now as I sit here in front of you trying to give you advice. You want to have a definite process in place for dealing with the government when it comes to you seeking data. You need point person, or at least a portion of your legal entity that can respond to the government. I definitely counsel prompt attention and triage when you get requests, and I know that's incredibly difficult because when I was prosecuting electronic crime matters, I know that agents working for me would serve just a voluminous amount of grand jury subpoenas and ECPA subpoenas as I was trying to gather information for my investigation. So obviously it can be very difficult to try to give prompt attention to these requests, but I think it's helpful to you as in-house counsel because the quicker you can pay attention to the matter, the easier it will be to respond appropriately and decide what exactly it is you want to do, whether that's full compliance, pushing back, negotiating with the government, or just an all-out fight. And again, so this bottom point, negotiating to limit the scope. I think for a lot of us on this side, it may seem a little intimidating at first when you realize you're dealing with a law enforcement investigation and you're dealing with FBI agents or federal prosecutors. And some people in government, I think, are intentionally intimidating. Not everybody. I'd like to say I wasn't intentionally intimidating, but I'm sure I was unintentionally intimidating sometimes just because the matters can seem so severe and from a government perspective, the requests are so urgent. Having said that, there's room to negotiate. So for example, I offered the example of the social networking website. We actually got, when we were investigating that matter, we did get some pushback from the small startup we were dealing with, and we ended up having a fairly amicable discussion about the most appropriate way to do what we wanted to do to investigate our case. The social networking website agreed with us that they were troubled there was an illegal child pornography conspiracy operating through their business. They appropriately expressed to us their concern that we would be violating the privacy interests of their customers. And so working with them, we developed an appropriate legal process that satisfied both their hopefully satisfied their need for privacy and confidentiality and maintaining a business that does what it's supposed to do, which involves maintaining privacy interests, and our need at the time to investigate a case. So there is room to negotiate, although I need to reinforce that sometimes if the principle is there, I think you need to pick your battle and stand up for yourself. So some of the considerations, I know you're well aware of these as well, but I just want to highlight them quickly. PR. Companies like yours sell themselves based on the ability to provide certain kinds of services. Often those services are predicated on privacy. So how important is it, depending on the kind of request you've received from the government, how important is it that you're fighting for that particular privacy interest? I'm not going to say that you should always fight for the privacy interest. Maybe sometimes the request outstrips that, but obviously it's something you want to keep in mind. Customer relations, same thing. You're trying to keep that privacy interest in mind. But here's the risk, poking the bear. Prosecutors, federal agents, by and large, are very, very pragmatic, and that's why there's room for negotiating with them. They're very pragmatic in wanting to get a certain result. That leaves room to negotiate and to try to work out solutions and carve-outs when you think they're overreaching. But if you decide that the bottom line is they are being overreaching and you really need to prevent them from getting what it is they're requesting, then you risk poking the bear and getting a fight from the other side. That's not necessarily a bad thing. Maybe it's something you think is important and correct, but it's obviously something that's worth pursuing in certain circumstances. And I offer the example of Google's decision to fight national security letters. And I've offered here at the end a few examples from industry that just present statistics as to how often various companies do comply with requests under appropriate legal process.
So one of the things is enterprises, again, a lot of enterprises, especially the smaller ones, aren't used to having the government show up, but obviously the government is more and more able to go after this information easily. We talked about that this morning. Let's go back, though. How much could you sell Rorschach today, do you think?
To the government, you mean?
Yeah.
Well, I think Rorschach is actually amazingly effective I'm thinking of slapping the government's hand, forcing the government to think twice about the data it's going to get and the kind of process it needs to use to get that data. So indeed, when I speak to prosecutors today, my former colleagues, and the issue comes up, what I hear is that they exclusively use search warrants to get information that previously they might have tried to get through an ECPA order, which is far easier to get than a search warrant. So I think it's amazingly effective.
And one of the questions that I know, Jessica, we talked about before is companies like ours, a ton of the data that we have isn't even our data.
Right. So it is the Microsoft problem in some respect. Although, because most of our customers are large corporations, they're probably in a better position to be able to fight it than an individual. So where we are, we're in most of what we do, we're allowed to give notice to our customers. In fact, most of our contracts require that we give them notice. It allows them to go ahead and fight their battles.
And as an enterprise, it's a good thing to make sure that with your third-party suppliers, your cloud vendors, that notice requirement is in there, unless Barack's colleagues come with a gag order.
Right.
Which is another problem altogether. Yeah.
Great. Well, on that, we're going to actually transition a little bit into the information border wars, because this information, as you know, exists in many different places. Multinational companies in particular already are dealing with this. And Microsoft just highlights that even more. So we'll go ahead and start there.
Great. Thanks, George. And thanks, Barack, for teeing this up. So I know there's a lot of information. I'm just going to walk through it pretty quickly here. But this is the outline of what happened in the Microsoft case. Essentially, the government served a warrant on Microsoft for information about an email account, and in particular, the email in the email account. It just so happened that that particular email was residing on a server in Ireland. So Microsoft moved to vacate it and said, hey, look, this email isn't here, it's in Ireland. And that would be an extraterritorial search and seizure, and we can't do that. You need to go and get the data some other way. The court actually refused to vacate the subpoena, or I'm sorry, the warrant, and found that, in fact, it was more part warrant, part subpoena, created this hybrid. And said, for that reason, this really isn't an issue, Microsoft. You have custody and control. You're able to turn it over. And in fact, it's really even not a seizure until you hand it over to the government in the United States. That ruling was upheld at the district court level. And it is now being, I think it's still being briefed with the Second Circuit. 28 technology and media companies, 23 trade associations, and 35 professors filed amicus briefs with the Second Circuit. So this is a huge issue for a lot of us. And in the interest of full disclosure, HP was actually on one of those amicus briefs. Because again, this implicates a lot of international issues that we struggle with every day anyway. But this is a real issue for us. See if I can get it to work.
I'll move it for you.
Thank you. And so these are some of the quotes from the briefing that took place at the district court level and at the magistrate level. Microsoft really took a pretty hard stand here, and with good reason. We, cloud providers in particular, host data all over the world. And there's so many privacy concerns in other areas of the world that, it's a tension that we always have. If we can move on to the next slide. But I did want to point out that this isn't really entirely new as far as tension of providing discovery or providing information in U.S. litigation or in a U.S. criminal case. When the discovery is overseas and when it runs afoul of foreign law. This 1987 case, Aerospatiale, the Supreme Court held that the litigants, it didn't matter where the data was. You're a litigant, you need to produce this data. So what if there's a blocking statute? They did put in a 5-factor test, but I had read somewhere that it's very rare that a court won't find in favor of producing the data that's overseas, according to this 5-factor test. The first one being, the importance of the documents to the litigation. And then, we go on and the U.S. courts generally want to see this data, is the bottom line. So the next. But what is new is ECPA was actually a 1986 piece of legislation. And just to put that into context, because it doesn't sound that long ago for somebody like me, but that was before the internet. It was definitely before the cloud, and it was most definitely before users that are now connected everywhere and all of the time. The other thing that's different with the Microsoft case, I think, is that this is compelling the production of someone else's data. So this is effectively deputizing Microsoft to go overseas and pull this data, even though technically they can do it sitting, in an office in California because they have access there. The data itself is on a server in Ireland, and it just creates these huge, huge issues. And then the other thing that's relatively new is with the growth of all of this connectivity, most countries in EMEA, most countries in Europe, Asian countries are coming on board, and as are South American countries, on some really strict privacy regulations. And that's something that we have to deal with all the time in the discovery space. But that is new. So this isn't just, a random French blocking statute. These are issues that we have all around the world already. The U.S. is probably one of the, we have privacy issues. I mean, there's certain data that's always protected. You're going to have your HIPAA-related data and, other types of data that's protected. But as far as the breadth of protection other countries afford, we're pretty non-private. To the next slide. So some of the questions that arose out of this case, or that are rising out of this case, that hopefully we'll get some sort of decision on, is, the first one is, what is location? And if you talk to Microsoft and you talk to people like me, it's the server where it's sitting. It's that physical thing that the government could go in and seize if they needed to, right? But again, like I said, it's virtual. So what's to say the person who's sitting in California, they have access to it. They can see it. They can download it possibly. They can, they can access this. And so is it really, is it access privileges? And then what does that do is it's related to, third parties being able to access things. So, we also want to kind of look at, not just the location, but, when are we going to need this information, for cases? If we need information prior to litigation, we're going to want to limit these things, and we also need it for eDiscovery, and there's law firm practices. So this was sort of as thinking through the Microsoft case and thinking through all of the implications that it has. There are some key takeaways, I think, and there's even more questions that are going to arise. And I'm sorry I don't have all the answers sitting up here. I don't think anybody does. I think, as Barack noted, we're dealing with a piece of legislation that is, very old. And just to be clear, I don't want it to sound like cloud companies, hosting services companies, want to be bad corporate citizens and defy the government, but they have a real tension right now between, being that good corporate citizen and trying to make sure we catch the child pornography, the predators out there. Nobody wants those, versus defending the privacy of most everybody else, right? And so it's a real tension that's happening. So one of the things that I think companies should do, and I was looking at this from a company that has its data hosted in the cloud, not so much as the cloud provider, but the company needs to know where its data is being stored. So I thought it was really interesting that we, 10 years ago talked about you have to get a data map. You always need a data map. And this was more in the scope of eDiscovery and collection so that it could make collection easier. It could make your Rule 26 conference easier. This is a little bit more fundamental. You need a data map because you need to know where that data lives, okay? So, are we, is your cloud provider storing European data, for instance, in the U.S., and how does that work? And do you know that, and are you keeping track with that and applying your safe harbor? And keep that map up to date. It can change pretty quickly, so you really do need a process in place to know, to refresh that map as it is. And then, on the Microsoft case, it's one thing to say this is and by the way, it's a drug case. And so there's a definite interest in law enforcement in getting this information. And that's all well and good. And in the pornography case, it's all well and good that we need this information. We need to prosecute these offenders or alleged offenders. But what happens when other countries start doing it to us? What happens when Russia knocks on the door of a U.S. company and says, we need you to provide this information about this particular journalist because they don't like what that journalist has been writing? That's a key fundamental issue for the United States, freedom of speech. And suddenly we would be, and Microsoft actually says this in its briefing, its opening briefing. It uses the example of the German police issuing an order for Deutsche Bank to open a safety deposit box to get a journalist's notes here in New York, and whether or not that's okay. And of course we would say no. And so that's really something we need to keep in mind, is turnabout's fair play. And if we do this, if it's okay for us to do this, what are other countries going to start doing to U.S. companies? And then, George already mentioned, and we already talked about contracting with, your cloud providers, making sure that you have notification in there. But you also might want to, make sure that your European data stays in Europe or in the jurisdiction it's located in. It can be difficult, and it's going to take negotiation, and it needs to be, pretty clear up front is the point. And if you are storing information abroad, is there a way to make it inaccessible in the U.S.? So, do you have to go with, for instance, and some people are saying this, and I would say absolutely not. You don't need to go with a European company to store it. But that's in my own interest, right? And then the final point had to do with the encryption of the data, so having users encrypt their data. There's a whole host, as Bruce has pointed out to me, of problems with doing that. But really, that's sort of the extreme of what people were talking about right now, is people really are up in arms about the Microsoft decision, and they're thinking, okay, so what can we do to prevent our data that's sitting in Ireland from coming over to the United States? And so these are things that people are thinking about, and I think some of them are extreme, but we're not going to really know until we get some things resolved here in the U.S.
So Bruce, I was going to ask you one of the questions, and we've talked before about going out and actually collecting data globally, and you've done that before.
I have.
And on occasion, you actually have to go and try and collect data on a global basis and get it out of the country. So even if you wanted to and you agreed to it, getting it out of the country physically can actually be the problem.
It can be quite difficult to get data out of the country. It really depends on that country's privacy laws, and there may be a component of technology being able to bring certain technology into or out of the country.
Right, we were talking about encryption itself, right? So some countries, you can't even use encryption to encrypt the data to bring it out of the country.
Correct. And our country has some rules with regard to exporting encryption outside of our boundaries as well.
Right, so if we export actually encryption controls, we can actually go collect data remotely, we can actually be violating ITAR.
Correct.
So, and then I was going to ask a question on, you used the word deputizing. I thought that was really good, basically the government deputizing companies to work on their behalf. Barack, there is actually a treaty process that the government can use to go and collect and go and ask for foreign evidence.
There is. It's the MLAT process, and don't ask me what the acronym stands for. I think at one time I knew, but I really don't remember. The bottom line is that it's a system for contacting other countries and getting them to agree to provide information, which can be incredibly burdensome from a government perspective.
So is this, does this indicate, hey, we have a great way to get around MBLAT now, we're just going to deputize companies to go and do this? You see...
That's certainly one way of looking at it, although the interesting, I think describing it as deputizing companies is accurate, it's apt. But I should also point out that happens in a number of other contexts as well. It happens in physical space also, although not necessarily with a search warrant. It happens with grand jury subpoenas all the time. Prosecutors will serve grand jury subpoenas, for example, on banks and ask banks to provide only certain information, and the banks will then give it to prosecutors. And those banks are often the overseas arms of domestic banks.
And then finally, the question that we had talked about at one point, we didn't put it on the slides, but I thought was relevant, is safe harbor safe? Right, so safe harbors, is a mechanism by which European entities can send what is considered private information into the U.S. Companies of all sizes, and of course providers of all sizes, rely on safe harbor in order to bring that in. The one quote that was up on the slide with the, from the OK Corral, I don't know if you guys noticed or remember that from the shootout at the OK Corral. The quote from the European MP who's overseeing a lot of the privacy things, there's real question about whether or not safe harbor is going to be the law of the land after 2015 or 2016, whenever it's up for renewal again. So how does a company, Jessica, like HP or any large enterprise deal with the fact we woke up one day and said we couldn't bring European data into the U.S.?
It would be tremendously expensive because a company, you know, HP is a global company, and we have HR systems, we have accounting systems. So this isn't about, you know, making sure that, you know, this isn't about segregating email, but this is about our actual operational systems and being able to integrate them and store them in one central location. And not being able to do that in the U.S. for a U.S. company that operates globally would have tremendous financial implications.
Yep. And then one of the other pieces in that there's a real likelihood, Safe Harbor currently is a self-certifying framework. So you self-certify and you attest to the FTC or the Department of Commerce, sorry, and they put you on the list. There's about 5,000 entities, I believe. The structure there, though, definitely looks like Europe is looking at some form of audit right to actually audit periodically entities that self-register, self-certify.
Well, Safe Harbor is really all about trust, right? And what they want to say is, we're going to trust you, company, to keep this data private. So you know what our regulations are. We're going to trust you. And allowing the U.S. government to come in and pull this information kind of makes it a little bit less trustworthy to them, maybe. Yeah. It's a question, you know, that we haven't. I can tell you that there has been some repercussions as it related to the Microsoft case already. Germany's up in arms. So it's not just Ireland. It's other countries in EMEA who are up in arms over this and saying this isn't right. And if you do this, then, you know, we won't do business with U.S. companies. We won't. And that was the basis of the amicus brief, of just the financial implications for U.S. companies this could have, because it's really just gonna separate us from the rest of the world.
Yeah. Yeah, my only point on the safe harbor is watch that space close, because there's real chances of material changes in the next year or two in safe harbor. And if you're a global company, you work with global companies, potentially a real sea change. Good work for you, though, probably, Bruce, separating all these systems out.
It could be.
So with that, we're going to turn this over, and we're now going to take a look at how does all of this start to fit together in what a model discovery process might look like, or what a model discovery exercise starts to look like in the future. And I use the future, AKA now, because we have some good examples that give us at least a little bit of a view into what this is going to be.
So as George spoke about when we started the session, we're seeing different types of data than we've had to deal with in the past. So if you look at our case study that we have up here, this may look strangely similar to a case that you might have been reading about or seeing on the news, where you have a large multinational corporation has a very significant security breach. In that security breach, the hackers were able to access very specific information, private information, healthcare information, HR-related information, confidential emails. And they've been able to put that up and put it up on their own web servers to make that available to the general public. As a nice added bonus, they were able to delete that from the corporate systems as well. So it wasn't only stolen, it was made available to everyone. So this may sound very familiar and very much like a real case that we've seen out there today, but it brings to light a number of things that we generally don't think about from a discovery perspective. When we think about data, we're generally thinking about human-created data, as George alluded to initially. I think, George, we can back up one more slide.
Oh, sorry.
We should have a slide in between there.
Oh,
It seems to have disappeared.
This might have been a version control issue, and I'll take responsibility for that. So, but you should be able to describe it.
Sure, I can certainly talk about it. So in the past, and in most of our discussion today, we've been talking about human-created data. What we start to be concerned about now with something like this security breach is now we may be interested in other types of data based on the downstream litigation that might occur. This may be things like system logs, security logs, DNS logs. I might even want to know what the security settings were on particular servers or systems. I might want to know about what was the policy and how was it implemented in terms of virus protection updates, security patches, and other relevant information. This data today is kept by and in many times generated by the system itself. So we don't have a real good process for putting that information on legal hold. We don't have a real good process for identifying and collecting that information. And if we did collect it, how are we going to process and review that data?
And Bruce, can you give an example of what these logs look like and how big they are?
These logs can be very, very large. I mean, they can be literally, gigs and gigs, hundreds of gigs of data, depending upon how you've got your log file set up. And they may be large text files, they may be large compressed text files. And so these aren't things that are readily or easily human readable. We don't have good eDiscovery tools to process and parse these and make these readable to us. We don't have good metadata with these artifacts. So if you're looking now to try to determine what happened, is this company liable, should they have done something, when did they know, what all happened and what the system knew, becomes a much interesting or much different challenge than we've had to face in the past. So we're really not well prepared for that today, and unfortunately that is today. That's the environment that we're dealing with right now. We're going to start being asked about those questions. We're going to start being asked about what were your system security settings, what was your policy for patches, what did the system log say, do you have a system security log? We're also going to start seeing, I think, some changes in how companies are starting to realize that this data may become discoverable, and I'm going to have to figure out how I am going to preserve it if necessary, how I am going to collect that information if necessary. And our eDiscovery vendors and product suppliers are going to have to figure out how am I going to process and display that data and make that available to my outside counsel or my other folks for review. So it is quite an interesting challenge that unfortunately is here today. So it's not the future, it's now.
So one of the interesting examples that we've used is that security systems generate tremendous number of alerts. If you've ever worked with any of them, no matter how good they are, they generate millions and millions of alerts. So if you were an average company, enterprise, you're getting tens and tens of millions of these alerts, potentially a day. And so this occurred over the course of, what, about a 3-month period, right? So you'd be potentially hundreds of millions of alerts. Somebody's going to come back and say, well, were you getting alerted that you were exposed in any way, that you had any sort of penetration, that you had any sort of data flowing out? And those are all the questions that are going to come up now in litigation.
Absolutely. Maybe other questions as well is, if and when you were aware, what steps did you take? Today, we talked about network boundary. Many of our large corporations have direct network-to-network connections with their suppliers and partners. Okay? If you're breached and now they're breached, whose fault is that? Okay? And what steps did you take, and what does your system tell you about the steps that you took?
And we talked about another case too earlier, which is the enterprise was exposed and the data was exposed because they failed to actually patch the system. Correct. With a known, was it 2009 vulnerability?
Yeah, I think if you go back and look at the now public, the Target breach, as well as the Home Depot breach, the specific malware that was used to actually, what we call screen scrape, or pull that data out of random access memory, there was a public advisory put out on that in the year 2009. So the fact that this was compromised, well past that date, is it the company's responsibility to have patched and secured that and made sure that that vulnerability no longer existed in their system.
So now being able to actually understand the patch management process and the patches that we actually have applied, which in big systems are constant.
Correct.
So with this, one of the other hypotheticals or questions was, so now, Barack, a foreign company, a foreign law enforcement agency says, hey, you guys lost a whole bunch of whatever it is, foreign country private data for our citizens, and we're going to compel discovery of data now in the U.S. How does the company respond?
So are you asking me my role now, or what I would have said 2 years ago?
You can pick the side that you want to jump on here.
Or both.
I'll try
both sides, Counselor.
I'll try to give you both, actually, or a fairly objective view. Look, obviously, I'd be incredibly concerned if I'm counseling a company when some foreign power, it doesn't have to be a foreign country, it could be the U.S., sure, asks for this kind of data.
I used foreign country because I thought it was a good kind of play it back against, the U.S. government. So.
Sure, no, and I get that. So it's an interesting question because when you've got somebody when you've got a government investigating a data breach involving your company, then to a certain extent you really do want to work with them, because they're hopefully doing something that helps you, which is prevent future data breaches, figuring out who has done this, hopefully helping you identify weaknesses and vulnerabilities in your system. At the same time, I think you need to balance that against the same kind of issues I try to point out that I know you're all well aware of. Okay, what are the privacy interests at stake? It may be useful for us to cooperate with this investigation now, but to what extent does that jeopardize other important things that we're doing for our customers? And of course, there's the PR issue. Does this in some way negatively impact our branding or how people perceive us? And of course, I don't want to be too superficial about this, but of course, that's important for businesses. Marketing is important for businesses. So these are all things that need to counterbalance that interest in cooperation. Now, the fact that it's a foreign country, well, that's a really interesting twist, because then cooperating with a foreign country will inevitably involve U.S. government involvement, and the question becomes, what if for some reason, I think we'd have to think a little bit about the right kind of scenario, but I can imagine a scenario where the U.S. government would not want the company cooperating.
Well, it's a little bit back to Jessica's point, right? So in this case, U.S. government may say, okay, but maybe the investigation in this case is against the Chicago Tribune, and it's a request from North Korea, or I mean that's probably a bad example, but still, but it's against the Chicago Tribune, and it's not against a company that lost tens and tens of terabytes of data.
Right. So that wrinkle obviously changes a lot of things and makes it all the more sensitive.
So Jessica, I'm not going to ask you to talk about our collection processes, but just thinking through, if you're sitting in the audience in an enterprise like this, all of a sudden log files, patch management files, structured systems, that's got to make you feel good in the morning.
It has to make me feel like I really need an expert, quite honestly.
Yeah.
You know, that's what we do. We rely on our security guys, our IT guys, to really help us in our collections, and particularly if there's something new out there, because, you know, I'm a lawyer. I like technology. I enjoy using technology, but I can't say that I know all of the ins and outs of it. And so I do rely on my experts to help me out there.
All right, well, excellent. Well, at this point, we're going to wrap up the comments and questions on our side, and we are going to open up for questions in the audience. There are microphones back. I see somebody holding one. Anybody who has questions is welcome to ask or stand up, either way. Go ahead.
How do you identify record custodians, especially when you're talking about systems?
Could you just repeat it one more time?
How do you identify record custodians, especially when you're talking about systems?
So I'll toss this to Jessica at first, because I know you don't want me to say this, but you cover a bit of the record side, but also gets back to your data map question.
Okay, so we often actually get requests for a custodian of records for particular systems. And so we have over 2,000 different structured applications within our company. Obviously, there's not one person who can respond to that. So oftentimes we will go to sort of that application owner, who's the expert on that application, and that's how we find it. If it's a little broader than that, then we might have to roll it up. But we do have to really look at who can talk about that particular application and how it works.
And Bruce, on the collection side, and you know, sometimes you have to go out and kind of sniff and figure out where some of this data is. What tools have you used or processes to try and
I mean, there are a number of standard tools. I think you can collect the data. The real question is being able to identify and know what data it is that you're trying to collect and where that data may live. As Jessica mentioned, that whole notion of a data map, it does become pretty critical, because in most data maps, at least the ones I've seen, they never talk about system-generated data at all. What applications would generate data, or what system data might be useful in these types of litigations. So I think it's not so much the way you collect it, but it's knowing what to collect is probably more important.
So obviously adding the machine-generated data at this point is going to be critical for...
Correct.
Well, and again, it depends on what it's for as well, because it might be that it's not even an IT person. It might be the person who actually put the data into it. So again, if it's machine generated, it's going to be the application owner. But if we need to talk to the person in HR, for instance, who tracks employment, you know, who's inputting that information, then, you know, we'll get somebody who's more of an expert on the actual information and how it's kept as a business record.
I wanted to know about the inevitable discovery rule. So you get all this massive data, the government gets it, and they find data that they weren't looking for that shows criminal activity with a party not even related to your investigation.
This is back to your, I'm going to grab a whole server, and instead of finding a breach, I found the child porn.
Okay, so we're talking about the plain view doctrine and the notion that if something is in plain view, that the government seizes data. If the government's, to offer you a physical example, if the government's has a valid search warrant to search a house, but there are drugs, the government is searching a house for paper records of some kind relating to some sort of white-collar offense, but lying there on the table is drug paraphernalia. It's in plain view. The government has a right to take it. The same sort of, currently, the government has a broad right to do the same thing when it's examining the voluminous data that it often seizes. Now, that's not an uncontested right in the electronic space. There's the CDT matter in the Ninth Circuit. I don't remember the precise year. I want to say 2010, 2011. Governments, really briefly, very, very concise rundown. The U.S. Attorney's Office in San Francisco was investigating, I believe, steroid use and seized a lot of data from a drug testing facility. The agent, if I remember correctly, the agent involved did just an incredible sweeping search of the data that actually, and here's the real problem, the agent's search of the data they had seized actually went beyond what the government was originally permitted to do. So after the fact, if I'm remembering this correctly, the government tried to cure it and did a bad job of curing it with a search warrant, and it became the government's argument essentially after a whole lot of process and litigation. Basically, the government's argument became, all we did was seize this data, and the stuff was there was information in plain view that we wanted, and so there was nothing wrong with this. Initially, the Ninth Circuit en banc, in a very, very, very forceful decision led by Judge Kaczynski, said, well, this is crazy. The government shouldn't be able to grab all this data. If the government's going to grab data like this, there needs to be a very thorough kind of filter process to make sure that the government at arm's length is going through this voluminous data and parsing what it should have versus what it shouldn't have, and the government needs to lay out this process very carefully. And then the government fought back even beyond that, and they tried to get the Ninth Circuit to hear it in a super en banc rehearing. The Ninth Circuit wouldn't hear it in a super en banc rehearing, but did kind of water down Judge Kaczynski's mandated process for searching the data. So that's a very long way of saying the plain view doctrine still exists in the electronic world, but there is room to push back when appropriate. But again, what it really boils down to, and I remember thinking this as a prosecutor, and I still think it now when I represent companies, what it really boils down to is just how awful search warrants and the search warrant process is generally when you're thinking about electronic data versus simply searching a physical space. Sorry, I'm going over.
One more question. Oh, two, we'll take two.
You made an interesting comment, Barack, about pushing back on government. The company I work in-house for frequently receives AG complaints or civil investigative demands, a subpoena. Some of them are very far-reaching and cause me much angst in collecting all the data that they want, and then only to find out that they don't even have a database to upload it to, so they want it in PDF format, and then they never review it, and meanwhile it costs my company $100 grand. Right. So when you say push back, does that apply also to I mean, we've had some big battles with some big AGs that have cost us a lot of money. And I'd be interested in hearing your take on that.
So I was practical as a prosecutor, and I remain a pragmatic defense counsel. I think you have to weigh the cost to your company. What are your company's principles? What's the cost to your company pushing back? Is it going to damage the company to push back? Do you care if it damages the company to push back? So there's no easy answer to this. It's a difficult calculation. But I sympathize with you. I know what you're describing.
But I think one thing we have said is it is okay to push back a bit.
Certainly. And in fact, well, let's take a step back. You know, when I hear push back, I'm thinking all-out fight. It doesn't have to be an all-out fight. What we can be describing is something as simple as a negotiation. Hey, look, government, I know you're asking, well, actually, this is an example that we didn't bring up before, but very often, I don't know if this has happened to people out here, but the government doesn't really know what it needs. It may put together search warrants or grand jury subpoenas thinking it knows the kind of evidence it wants, but completely unable to articulate either for technological reasons or for more prosaic reasons why it wants certain things or why certain things actually match up to whatever its investigation is. So I think it makes perfect sense when you get some sort of completely inarticulate, inexplicable grand jury subpoena or search warrant to call the prosecutors, not the agents because they tend not to want to speak, but the prosecutors, and say, what are you guys after? Because this makes absolutely no sense to us. If you can tell us what you're after, then maybe there's a way for us to, comply with process, although we really, we do have some privacy interests here, but the way this is articulated is overbroad, raises all kinds of privacy and confidentiality concerns, and if you really want this, then we're going to fight it. So I think there's a conversation to be had with the government.
Just very briefly, does the government have the right to compel disclosure of a decryption key?
So candidly, I have not re-examined that case law for a while. The last time I actively looked at that, yeah, they can do it. Yes.
The last case was along the line, the analogy I think they used was if you can compel somebody to give you the key to the safety deposit box. I think they actually used that example.
Yeah, I have another question, and maybe with the compelling of the encryption key, it's moot, but do you think there's going to be a trend where third-party providers are going to be forced to have zero-knowledge encryption on all their clients' data?
The answer is some would like that. We absolutely already have requests today saying we would like you to provide the infrastructure, provide the applications, but have no knowledge of the data itself. For certain solutions that we provide in the regulatory space, we can't do that because we're obligated to be able to actually produce on behalf of the firm to the government as necessary. So there are times when you can, times when you can't. The problem I will say practically is if your provider can't really see data ever, and it's always encrypted, when things go wrong and they need to start troubleshooting and trying to find out what problems are, it becomes really hard.
What about having a different custodian of the key so that the third-party provider doesn't have
So we have one model where we service an entity in Switzerland, but from somewhere else in Europe. And actually the model that we use there is they have a key that they give us for a period of time to get in, do what we need to do, and then they revoke the key. And the next time we need to get in because something went wrong or they want us to help them look at something, they'll give us a new key. And so the customer is holding the key, and then it's a temporary key that they grant and then revoke at almost kind of real time. It's an access key, so it's not an encryption key, it's an access key, but it's the same idea. Well, look, we'll be around, so I appreciate everybody staying and joining the session. I thank the panelists very much for taking the time and making it out here, and I hope you guys have a good rest of the day.